mute your microphones when not speaking. On that note, I'd like to now welcome representatives from the Australian Airports Association to give evidence today. For the Hansard record, could you please state your full names and the capacity in which you appear before today's committee?
Morning. Hi, Simon Westaway. I'm the CEO of the Australian Airports Association.
Morning. Sanjeev Sathaya. I'm the Senior Manager of Regulatory Affairs with the Australian Airports Association.
Thank you for that. Although the committee does not require you to give evidence on the oath, I should advise that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. And due to the short time frame the committee is working within to complete its review, please try and answer all questions or provide information to the best of your ability in the evidence today. And if any questions are taken on notice, written answers will be required within a very short time frame. I'd now like to invite you to make a very brief opening statement, if you have one, before we go to questions.
Yes, we do. Thank you. Good
morning.
Thank you. Thank you for this opportunity to appear today. The AAA represents over 340 airports across Australia. Now, this includes our major international hubs, regional and small aerodromes, and we also have 150 plus corporate members which support aviation nationwide. Our members are essential in connecting communities, facilitating trade and tourism, and supporting livelihoods. Today, 40% of Australians annually interface with a local airport, which we think is an important point. The AAA supports strength in our aviation security. However, we have genuine concerns about the Transport Security Amendment Bill 2024, which remain unaddressed, and we detail this in our considered submission. The AAA notes the inadequate consultation process by the Cyber and Infrastructure Security Centre, or CISC. Whilst appreciating our pre-election cycle that we are now all feeling like we're in, only two formal consultation phases with industry have actually occurred. The first allowed for minor feedback and legitimate concerns were overlooked. The second, a first-pass impact analysis, was a rushed process. Just a week for stakeholder response before the bill came before Parliament. A significant issue remains regulatory duplication caused by CISC's proposed all-hazards security framework. Contrary to CISC's claims, comparable international frameworks do not adopt such a model for aviation security. Examples that the CISC used in their submission from the UK, the USA and the EU touch on natural hazards in passing or are focused on critical infrastructure, but not aviation security. Australian airports already manage natural hazards under the Civil Aviation Safety Authority, CAS's Manual of Standards, which is MOS Part 139. These require aerodrome emergency management plans aligned with the International Civil Aviation Organisations, ICAO's Annex 14. Meanwhile, ICAO's Annex 17 governs aviation security and does not integrate natural hazards. This is a further example of unnecessary regulatory duplication, a disappointing constant across Australian aviation today. Compliance costs are a major concern for us. By the CISC's own estimates, implementation costs could cost our sector nearly $1 billion over the next decade. This is an additional expense for airports across Australia, particularly for our small regional airports, who will find it very difficult to absorb these costs. In 23-24, our major airports had over 97 million passenger throughputs, while our regional and rural airports had a little over 18 million in throughput passenger movements per annum. These costs will inevitably be passed on to the flying public, further increasing travel expenses and in a disproportionate way will impact regional and rural aviation harder. Finally, while security is paramount, pushing legislation without due consideration is problematic and we believe is actually bad public policy. The AAA recommends a minimum 24-month compliance timeline rather than the proposed 1 year. This is to ensure effective implementation without the unintended consequences. In conclusion, the AAA urges the committee to refine, I should say, this bill to eliminate regulatory duplication, ensure a proportionate risk-based approach and mitigate the cost burdens. Thank you.
All right. Thank you very much for that. Are you happy to table that opening statement for us?
Absolutely.
Yeah, okay. Well, I'm going to hand the call over to the Deputy Chair to kick off with questions.
Thanks very much, Chair. Good morning, gentlemen, and thank you for your appearance today. That's a pretty damning assessment of the, particularly in relation to the consultation performed by government in relation to this bill. I want to, as a proud regional member, and I note, there are other members of this committee that are also regional members, but I have a terrific local airport in my electorate, Sunshine Coast Airport.
Yeah.
And I want to, without being too parochial, but it is perhaps a good example of the discrepancy between large airports and their capacity to be able to deal with the sort of imposts that are brought upon them by these sorts of regulatory changes, and smaller airports like Sunshine Coast Airport. Do you want to speak to how smaller regional airports are going to deal with these sorts of imposts should they be introduced?
Yeah, thank you. I'll take that. My learned colleague Sanjeev can also provide some add-ins as we go forward. Look, we've got a real complexity in this country in our airport sector and our aviation sector. So around 200 of our airports across the country are owned, managed and run by local government, local councils. At least 60% of those run at a loss, and many of those run at a significant loss. Now that's an issue for another day, but if you've got to sort of think about that in that context. So for our major airport gateways, Sydney, Melbourne, Brisbane, Perth, Canberra and the like, they operate at a different business model, but of course they're dealing with passenger throughputs 10, 15, 20, probably 50 times the type of flows that you would. Now, in some ways, Sunshine Coast Airport probably sits outside that. The passenger volumes there and are moving towards 3 million passenger movements a year, and it's one of the fastest growing airports coming out of the pandemic. So they're in a different space, but nonetheless, the issues around increasing costs still impact an airport like Sunshine Coast as much as they would obviously smaller regional airfields.
Do you think that smaller regional airports, particularly regional airports, are aware of the security risks that are being faced and that are trying to be addressed by this legislation?
I believe they do. The issue for them ultimately is cost, but it's not just cost per se. It's regulatory overlap. It's the increasing regulatory burden, and when you have duplication, and this is perhaps I'll get Sanjeev to say something here. When you get duplication, that's really becomes a bit of the oxymoron in this whole thing. We absolutely get the importance of security. Completely. I mean, safety security is the number one priority, not just for the operations in and out of airfields, but also the people engaged around that. I mean, that's a guarantee, has to occur. But when you've got duplication, and sadly this bill is pushing duplication either deliberately or opportunistically or inadvertently, this is what we're facing, and that's why we're saying we need a bit more time here, and also we need some better consultation, and let's work it through. No one's saying there are not significant security risks that our nation's facing, perhaps facing inside our own borders, but there'll be a burden placed particularly on the smaller airfields, both regional and rural airfields, that they won't be able to meet, and the owners of those airfields, local government in many cases, will have to be making some decisions around how they seek to meet that. So,
you've spoken a lot about that duplication. Is there something that perhaps you're not missing, that the duplication you're concerned about is not real duplication? There might be a bit of overlap, but that the current laws may not necessarily be meeting all of the contingencies that might arise. What is the rationale of this legislation, and why is it so duplicative, duplicitous?
Yeah, sure. I'll answer that question. The challenge here is that they're trying to. I think the bill's trying to bring together the various responses or considered responses the government needs to take in response to the national, security risk that faces the aviation sector and other sectors. However, despite the fact that the consultation process has shown that there's been, we've raised duplication concerns, not just us, but others, It's been acknowledged as well that duplication has been acknowledged by the department. If you look at the first impact analysis, it actually highlights those concerns. It shows the proposed position, the fact that stakeholders were concerned about this, but then that has effectively been ignored, and the position will remain the same, and we'll sort this out later kind of approach. And that of course raises concerns because we can see the problems up front in the bill, and if there's problems up front in the bill, well, what does that mean for the regulations? So we'd rather see the bill correct and refined and targeted in its in what it's aiming to achieve, rather than obvious duplication. For example, CASA already oversees natural hazards and the way that they're regulated and managed at airports in Part 139 MOS that was mentioned earlier. And so government already has assurance through CASA and its regulations that that airports are in fact aware of this this potential threat and are mitigating against it.
Is there anything in this legislation that addresses capacity building for smaller airports?
Not that we've seen so far. And one of the challenges that we're faced with here is that it's not apparently proportionate. We've got a one-size-fits-all solution, and that again has been raised in the consultation. There's no concessions made in what we've seen in the bill so far to regional airports, and that they're expected to comply with the same requirements as major airports, which is not the way in which we understand the government would like its regulatory agencies to approach regulation. So there's the document RMG 128, which is managed by the Department of Finance because it's all about efficiencies, and this regulation isn't proportionate. It's just, as I said, a one-size-fits-all solution that really won't fit smaller airports at all.
And perhaps just add one more point. So we'll talk a little bit about what these costs are, real costs. So just in terms of what is being proposed in the bill, so for vulnerability management services, right, the cost could be between $50,000 and $200,000 annually. An IT security audit, there's a bit of a delta here in the range of price between $3,000 up to around $50,000. We're not making these figures up; these are real figures, and we're talking about some of these airfields.
Where have you got these figures from?
From our own work and from our own members.
We're happy to take that on notice.
Yeah, we can take it on notice and provide more detail around that if you so wish, because these are the real world costs that we have to deal with from airfields that may only move 20, 25,000, 30,000 RPT passengers a year, or a critical airfield for air ambulance and things of that nature. So.
Pardon my ignorance, but is there a sliding scale of security that these airports need to address, or is it if you're an airport or an airfield, you've got to meet these requirements under this legislation, no matter how large or small?
That's correct, yeah. That is how it stands at present.
No matter how large or small?
Correct.
So does it also apply in relation to airports that would, or airfields that would just generally deal with general aviation?
Yes.
Yeah, it could.
Yeah, so where the security screening legislation does have thresholds, there are no apparent thresholds in this legislation.
So an airport or an airfield like in the member for Flinders, like Tyab Airport, for example, that just is general aviation, has no paying passengers, they would have to meet the same criteria as Sydney Airport.
I think that question is probably best directed to the department. To be fair, I wouldn't want to mislead the committee.
All right.
Airport, but we'll ask them later.
Yeah. Okay. You can come back to me if you have time, Chair.
Yep. All right. Swanson.
Thanks, Chair, and welcome. Thanks for coming along and being the proud representative of Newcastle Airport. I don't want to try and out-airport you, Chair, but we have a particularly wonderful and growing airport in Newcastle. Thanks for being with us today. I just want to preface the question with the idea of timeframes. In 2021, the former government commissioned an independent review. Now, to my knowledge, this bill backs in all of the recommendations from that independent review. So that's going back to 2021. So in terms of the consultative process, would you not agree that this has been, in the wind and been discussed and been spoken of in airport circles now for the best part of 4 years?
Sure, I'd say that's true. However, I wouldn't agree with the assertion that it backs in all of the Heartland Review's recommendations. For example, one key element in terms of the consultation was the concept of co-design, that this legislation would be developed with a co-design process, and that certainly was not the case.
And also the premise, Mr Westaway just spoke about it. We know that we are living in an increased time of threat, diverse threat, degraded security settings in some respects. So the threats are real and there. We heard from the Director General of ASIO last night that, the world is a rapidly changing place. So I think that that's also given some context around, the 12-month time frame rather than 2 years. Is that 2-year period fixed in your mind? Are you at all flexible on that?
Yeah, of course, we're absolutely flexible on these sorts of things, and we would like to be, consulted and have that sort of concept discussed and considered. In terms of the threat environment, yes, we do understand, that the terrorism risk has increased, that the threat status is currently at probable, and but what I would say is that throughout all of this, airports have always taken their responsibilities and obligations around aviation security absolutely seriously and do whatever they can to comply, and that's their goal. However, I wouldn't say that there's anything in this bill that appears to be critical. It's not plugging any special gaps that already that might exist in the legislation. It could be perceived as a bill that might harden the position in relation to certain threats. Things like introducing, systems testing and so on. But it's not. There isn't anything that I would describe that's been critical that absolutely warrants being implemented within a 12-month time frame necessarily.
So in relation, I just want to draw your attention to cyber security, because that really is the area where we're seeing just an acceleration, if you like, of all sorts of attacks, and particularly technology. We've seen with some of the emerging technology with AI in recent months that this is, really something that we must take seriously. So I'd just like your thoughts around that. Given the tempo must increase, can you talk to me about, the cyber threats that all companies face, but, airports particularly, face vulnerabilities, and we've actually seen that play out.
Yeah, again, airports are all right across cybersecurity. It's something that, again, airports take very seriously, and they already have mitigations in place for it. And I'll point to the fact that there is the SOCI Act that's in place, and the airports do already have reporting obligations on cybersecurity. I see the bill or the department sort of notes that there has been an increase in cybersecurity attacks on the transport sector as its justification for effectively duplicating the SOCI regulations. They've talked about mitigating those reporting responsibilities by having a single portal through which the airports would provide their compliance reports, noting that one would go to that while they would actually go to different sections within Home Affairs. What does that tell you, or what does that appear to tell me, is that Home Affairs is already covering off those particular requirements under the SOCI Act. We haven't been told that there are any differences between the reporting requirements for the two pieces of legislation. So one can only assume it's exactly the same information but being provided to different areas of the same department.
But to go to your question around 12 months versus 24 months, it's a good question. And what we're saying is that gives us the ability as a sector to work more effectively towards that. I know you've talked about time, but we've got to do with the moment that we're facing now, and we believe that the 24-month is a really strong concession from us as a sector. You'll probably hear from other witnesses from other parts of the industry today. That extra year of time will allow us to be able to better prepare towards what the intentions of this bill are trying to achieve if it becomes law. So We're trying to be practical, but we've got to be realistic. I think that's what we're saying. We have to be realistic, and there is duplication in this bill. It's a criticism we'll continue to call out no matter who is running the country, that there's an increased approach towards duplication as a way of addressing issues in terms of the regulatory and legislative framework that doesn't necessarily create better outcomes.
Thanks. Thanks, Chair.
Thanks for that. Ms Swanson. Now, Ms Mackenzie.
Just a quick one. Based on your evidence today and what I've read in the submissions, I can't quite work out if you'd prefer 2 years or to go back to the drawing board.
Well, I don't know that we need to go back to the drawing board per se, but I think our concerns certainly need to be addressed in this bill. And if they can't be because the horse is bolted, well, the regulations really do need to ensure that they do address those concerns.
And if it were to be going back to the drawing board, would you suggest a kind of collaborative co-design process? Because that's what I'm hearing. Including your smaller members, because they're the ones which will...
I think co-design's critical. I think you'll hear from other witnesses today who'll talk, and from the airline side will talk about the importance of co-design. I think that's actually imperative.
And has that been the model, to your knowledge, elsewhere? I don't suppose there'd be many jurisdictions like ours, actually, now I think about it.
It's definitely becoming what one would consider best practice in government and regulation just generally, to help ensure that the legislation that's ultimately implemented is fit for purpose.
And the opportunity cost, so if this goes through in its current state, how much time are your members spending trying to get their brain around this rather than just running an airport?
Again, I mean, if you look at regional airports, they're already dealing with those that have met the thresholds for screening requirements, for example. That's already a big headache for them because it increases the cost of operations. 60% of regional airports are already operating at a loss. They've got to hire staff. Ongoing operational costs can be quite considerable, up to $500,000. And then you look at the cost impacts and implications of this legislation. If it were to apply to them, which it appears to, then it starts to become really problematic. A longer time frame would also help airports spread the costs of implementing the legislation.
It improves their planning. I think they've just got an ability to plan and then to implement. And the changes in security were necessary, but obviously that's a significant impost, and it's been a big change for aviation, particularly at our regional and rural ports.
Thank you.
Chair, can I just ask one question?
Sure.
Arguably, an analogous country in this space would be Canada. Large expanses, long distances between airports, and many small airports, regional airports. What's a country like Canada doing in relation to this issue?
Well, you'd have to look at ICAO Annex 17, as being the guiding light for what airports are expected to be doing around the globe. And one thing that I can tell you that they're not doing is applying a all hazards approach, a security approach to security, which is one of the key pillars of this particular bill. It just doesn't fit, especially the natural inclusion of natural hazards in a security framework. Annex 17 doesn't mention natural hazards at all. So why are we incorporating natural hazards in our security response? That's already covered off by people that are experts in emergency management, and airports already have aerodrome emergency management plans that have those responses in place for those particular threats.
All right, thanks.
Thanks, Deputy Chair. Okay. Well, thank you very much for your attendance today. You'll be sent a copy of the transcript of your evidence and have an opportunity to request any corrections if any need to be made. If you've taken any questions or notice, the Secretary will also be in contact with you about providing a response in a timely manner. So thank you very much, gentlemen.
Sure.
Thank you.
We'll now get ready for our next witnesses. We'll have a round table of airline operators. We'll just suspend very briefly and get our next witnesses ready. Thank you.